Hey folks, Tom Hinkle with Safe Systems, also known as a compliance guru. Coming to you today to talk about a piece of proposed legislation, new legislation that the NCUA is proposing and is put out for comment regarding a new requirement for you to notify them under certain conditions of a cyber event, a cyber incident. So again, it's a proposal. The final may look different from this proposal. In fact, probably will, but I wanted to unpack the proposal for you, show you how you can submit comments so you can weigh in if you like, and at least give you a little bit of a heads up on what you might expect. So yeah, new cyber incident notification rule. And when we look at these new rules, proposed new rules, we kind of pass them through a filter of, are they likely to come to pass? Some do not. Some simply die in the comment process or are just postponed. However, we feel that this has got a pretty good chance, an excellent chance, in fact, of becoming law. We have a magic 8-ball we use for this, and we're gonna grade this particular proposal as you may rely on it. And I say that because the other agencies, the FDIC, the Federal Reserve, and the OCC have all passed very similar legislation, in fact, just earlier this year. So we believe this will come to pass. We don't know what the final rule will look like, but again, we think it's instructive to take a look at the proposal to see what we can glean from that. So what you may be asking yourself is, why do we need a new rule or a new law? We already have requirements in place to notify under certain conditions, and that's absolutely true. Currently, financial institutions, federally insured credit unions, FICUs, may be required to report under certain conditions through the SAR. In addition, you currently are required to notify the appropriate agency as soon as possible when you become aware of an incident involving unauthorized access to sensitive member information. You're also required to notify the NCUA within 5 business days of any catastrophic event. Of course, that would be more like a natural disaster. So if these exist now, why is there a new law being proposed? Well, frankly, because the NCUA does not feel they're getting timely information about these cyber events. So that's really what this is geared for, is to provide more timely notification. So this is the requirement. It's actually proposing a change to Amendment B of 12 CFR Part 748. If you wanted to look that up, so it will actually be incorporated into the new law or existing regulation, a new piece of an existing regulation. Simply put, any cyber attack that causes disruption to a federal insured credit union's business operations, vital member services, or a member information system, right? Think about the IT, the infrastructure on which that information resides. Any disruption to any of those must be reported to the NCUA within 72 hours of your reasonable belief, and we're going to unpack that term here in a minute, that you have experienced a cyber attack. So within 72 hours of you making the determination that you have experienced a cyber attack. Now let's unpack that just a little bit. So, okay, as soon as possible and no more than 72 hours after, right? Take a look at these terms here. A reportable cyber incident, so we're going to get to how that's defined. And the way you define that then is critical to determining whether or not you need to notify. So a cyber incident, any occurrence that actually or possibly imminently jeopardizes without lawful authority, confidentiality, integrity, availability of information, or actually or imminently jeopardizes without authority an information system. So really they're sort of saying, look, if it's a malicious act, it needs to be classified as a cyber incident. It's possible, though, that there could be a botched upgrade or a patch applied that brought your system down or something like that. The lawful authority here is the key to understanding of anything that is not malicious is likely not to be included in the notification requirements. So here is the qualification to go from a cyber incident, right, to a reportable cyber incident, because there's another sort of whole degree of classification here to get from cyber incident to a reportable incident. So you can see the three criteria there: substantial loss of CIA of a network or system, the results of unauthorized access, right? A disruption of a system resulting from a cyber attack or an exploitation of vulnerabilities. Right? Again, there's a malicious intent there, right? Or disruption of your business operations or access to sensitive data caused by a compromise of a QSO, in other words, a service provider, right? Or any other third party that's hosting data that's in your supply chain, okay? So the key to these three are that, for the first two anyway, it's a malicious event, right? And it affects your systems or your member data, right? And the third element of that is a third party that you rely on, a critical third party that suffers some sort of a compromise. So this term reasonable belief, it's kind of important that we unpack this term as best we can. Again, this is the proposal, it's not the final, but I'm hoping to add clarity to this term between now and the final. But essentially the 72-hour clock does not start until you have achieved that level of reasonable belief. Okay, so it's kind of critical that that you understand that all of this is hinging upon how you define reasonable belief. Okay, it also says that that the board anticipates it's going to take you a little bit of time to form that reasonable belief. So now again, the clock isn't going to start until you've made that determination. So they're saying, look, we know it's going to take you some time to get to that point. And until you do, we're not going to start that, require you to start that clock. And they also recognize that you may not be able to form that belief if it occurs outside normal business hours. In other words, you're not going to even work on it until you find out about it. It could be the next day or the next working day, business day. And only once you've made that determination that you've experienced a reportable event would the clock start, would the 72-hour clock start. Okay, so you still have a lot of control in when you notify. There's another element to this which I thought was interesting because it's also part of the new rule that was incorporated earlier this year for FDIC, OCC, and Federal Reserve institutions that pulls these critical third parties into this notification loss. So essentially, then the new rule will require you to notify the agency within 72 hours again when a third-party provider has notified you that they've had a compromise, right? Or, and this is the second part of that, upon you making a belief, a reasonable belief, that this third party has had a compromise, right? So either they tell you they've had a problem or you suspect they've had a problem and you form a reasonable belief. Whichever of those two occurs sooner. Okay, so there is no predefined template for how you report at the moment. However, they do expect that the report should contain certain elements, a brief description of what happened, what functions are or perhaps will be affected. Those would be your internal functions, right? The estimated date range, as far as you can tell, as to when this incident took place. If you know, when you file a report, if you know what caused it, what vulnerability caused this particular incident, you can put that on there as well. If you know who the bad actors are here, you may not, probably won't at this point, but if you do, you should include that as well. And then try to estimate the impact to your operations if you can. Again, if this is early on and you're just trying to meet that 72-hour deadline, you may not have a lot of information about impact or any of these items, frankly. But these are not requirements, but they expect that if you can include these in the report, you should. All right, a couple of final thoughts here. Again, the final rule may provide a shorter reporting time frame. The other federal agencies use 36 hours. NCUA is proposing 72. I suspect we'll see that shorten as we get a little closer, but we'll have to see. Again, the initial notice, the one that we just talked through, is going to be, by definition, going to be limited, right? You're not going to have a lot of information. That's okay. They don't expect a full analysis at that point. Again, there are no prescribed forms or templates. There are some suggested contents, which I shared with you, but there are currently no forms to fill out like an SAR or something like that. The notice can be provided to whoever your designated point of contact is at the agency. If you have a current point of contact, you can provide it to them by email, fax, or telephone, or any other method that they may prescribe through guidance. My guess is that when they get to the final stage, they probably will have a designated email address or contact individual, at least the other agencies do in their final rule. And finally, again, reporting is not required for any event where the incidents or whatever caused the outage is performed in good faith, right? So in other words, they're pretty much limiting this to a malicious event, okay? If you want to submit comments on this, a comment period, I think it was just supposed to be open, but I went out to the Reg Info and I did a lookup on the RIN number, and I couldn't find anything out there yet. So it could be it's just not been posted in the Federal Register for a comment period, but you can submit comments three ways, one of three ways, either through the website, by sending a regular snail mail, I guess, to the NCUA at that address, or by email at pracomments@ncua.gov. That is what they're saying is the preferred method of communication for comments. I'm going to toggle over to the actual thing here so you can see the parts proposed, the NCUA number, the RIN number, and the rest of the information for submitting comments. So I hope this is helpful. We are going to keep our eye on this, obviously, and when it's finalized, and it's going to take at least 60 to 90 days from the time it's submitted in the Federal Register, so we are several months away. But it wouldn't be a bad idea for you to kind of get a sense of where it is currently. Submit comments if you feel necessary to do that. But my guess is we're going to see some sort of a change in the notification laws for credit unions before the end of the year. Anyway, that's it. I hope this is helpful, and thanks so much.